All right, welcome. We're going to get started. This is just my presentation on moral principles, professional values, and ethical decision making for professional school counselors. My name's Joe Bean. Hopefully, we've met each other once upon a time. Generally, I'll present on things related to civil liability, tort law, things that school counselors get sued for, and how to avoid that. This is going to take just a little bit of a different spin, and we're going to reflect a little bit more on the codes and different things like that. So here's what we're going to do in today's lesson. The session will educate participants on how basic moral principles and professional values are applied to legal and ethical decisions professional school counselors are challenged with daily. At the conclusion of the session, what we're doing today, you'll be able to implement a 14-step ethical decision-making model and understand a new way of thinking from a legal perspective. So I'll talk a little bit about civil liability, different types of law, hierarchy, um, of our burden of proof, moral principles, professional values. I'll talk about some ASCA position statements. And hopefully you can pull that all together and just give you a different way of thinking when you're challenged with an ethical decision. All right, so today's learning objectives. As with everything I do, there's always going to be a knowledge, a skill, and awareness component. I think those are the three most important things in education as far as counselor education is concerned. Personally, I think awareness is the most important thing that we can do as we move forward in this professional development journey. Knowledge is easy. We've always proved that we could graduate from college, we could graduate from graduate programs and master's degrees and second master's degrees. So we can attain knowledge pretty easily. Awareness seems to be the more challenging component. And skill falls somewhere in the middle of that. So knowledge is going to be for us to gain a legal knowledge by learning about decisions from some American court systems and how they've directly impacted how professional school counselors understand civil liability and ethical decision making. Skill will be to implement a 14-step ethical decision making model. And really, the 14 steps come from different ethical decision making models that already exist. Just kind of putting them together, something that's more specific and special to school counselors. And then lastly, participants, you will be challenged to consider your own explicit and implicit bias and become aware of the ethical and legal challenges that have the professional counselors have overcome. So what are the things, explicit and implicit means, what are the things that you know, and then what are the things that you don't know about yourself and what makes you think and what makes you tick and what maybe upsets you. So if we were in person, the way that I'd like to do this is I'll ask you three prediction questions just to see what you know before we get into anything deeper. My first prediction question here is, what is the difference between ethical standards, professional values, and moral principles? For the sake of time, I'm just going to move on, but if you're watching this at home, this would be the perfect opportunity to just stop and think for a second. What do you know? What's the difference between ethical standards, professional values, and moral principles? The second one are going to be, what are the differences between laws, ethics, and policies? You have laws because you live in a state and states have laws. You belong to a professional organization. They have ethical codes, and then you probably work for a school district that has policies. And then lastly, what are some of the steps that professional school counselors can take to be protected from lawsuits? So civil liability or tort law, negligence, I'll use it interchangeably throughout the presentation. But what are some things that you can do and what are the important things that you can do? So really the first thing that we're going to start with is just ethical standards and the prescriptive norms representing a consensus opinion within a profession regarding best ideal practices. Ethical standards aren't necessarily given to us by someone, they're created by us. So you'll see my last bullet point here. Ethical codes are created by members working in a profession. So these are us. These are school counselors, people who are working in the trenches, people who see the issues, the ethical challenges that present themselves daily. And what we do is we sit around and we say, okay, as a profession, how should we approach this? What is reasonable? What is unreasonable? What is doable? What can't we do? And then we write codes. The one thing that I want you to take away from this is when we talk about best ideal practices, there's a legal standard called the ideal person standard. So the one way to think about this, and this is kind of go back to that prediction question I asked you a second ago. What I want you to do is think about the most ethical, competent professional school counselor that you know, the one person that no matter what the challenge is, they're always going to do the right thing every single time. One way to avoid lawsuits is to think about that person and then do what they were going to do in the same situation. If you do less, you're doing less than the ideal practice, and that's how sometimes we get ourselves in trouble. If you don't know what that person would do, the second thing you could do is call them and ask them, because those consultations go a very, very long way. So ethical codes help us communicate to members of an organization the professional identity and collective values and principles of the profession. What is it that we all agree upon as school counselors? What is it that we all think is the right thing to do? The reason that we belong to professional organizations is, well, first of all, ethical standards is one piece to that, because by belonging to an organization, let's say the Pennsylvania School Counselors Association, or ASCA, for example, you're telling other practitioners in the profession, I hold myself to a higher standard than, maybe someone who wouldn't belong to a professional organization. And professional organizations are much more than professional development, in a way to get, the hours that you need either for level two or, for the different things that we do. You're really holding yourselves accountable. You're showing each other that you're held to a higher standard, that you hold yourself to a higher standard. And you're also educating members of the public about what it is that you do. You're saying, so me, for example, I would say, well, people ask me all the time, what's the benefit to having a national certified counselor credential? It doesn't get me anything at my job. It doesn't really mean anything. I'm not sure what the purpose of that is. Well, basically, you're telling the public that, hey, I hold myself to an even higher standard, the highest standard possible. And by belonging to the different associations and the different ethical codes, you're saying, and by belonging to these associations, I hold myself to a higher ethical standard, or the highest ethical standard in the profession. So when folks come to me and they say, can you make a recommendation or can you make a referral? I'm looking for like a counselor, for example, a mental health counselor in the community. Can you make a recommendation? And I would say, look for someone who belongs to the American Counseling Association, someone who has a license as a professional counselor in Pennsylvania, someone who has a national certified counselor credential. I don't have to know those folks individually, but I know what they've put themselves through and what they've promised their profession and each other. Ethical codes should always be practiced, but laws and school policies must also be considered and followed. Sometimes they're not always consistent with each other. Here's where that becomes a problem. Laws trump everything. So regardless of the law, you can like it, you cannot like it, it's the law. And what happens when you don't follow the law? Well, the law can take action against you. There could be some type of legal action taken. Obviously, when ethical codes and laws don't always align, what our professional organizations do, whether it be ACA or ASCA or PSCAs, we go and we do Hill Days and we call our legislators and we advocate for changes in the laws because we want our laws to align with our ethical codes. At the end of the day, if we don't follow laws, you're fined. You can go to jail. Um, and I don't mean we don't normally go to jail. I'm thinking of a time that, a court had subpoenaed some documents and the counselor said, no, I'm not giving you those documents. And the judge says, well, then you could sit in jail until you get the documents. That's just what the law has over us. Even though our ethical codes might say, no, they don't have the right to that, or school policies might say they don't have the right to that. So laws trump everything else. Ethical codes, we created them. That's the best practice as far as our entire profession is concerned. There are hundreds and hundreds of thousands of people who work in the profession that know better than everybody else that say this is what we're supposed to do. But sometimes laws don't always align. School policies, if you violate a school policy, what happens? You'd be fired from your job. So sometimes you have to follow a school policy even though you don't like it because you want to keep your job. What I would advise you to do is if you have a school policy that is so out of line with your own values, look for another job. I mean, I know that's easier said than done, but otherwise, if you want to continue staying employed with your employer, then you got to follow their rules. So become familiar with those ASCA ethical standards. Know that there are going to be challenges in the application of these codes in your daily work. You'll see on the third one down, it says codes of ethics, they're not cookbooks. It's not like you're baking. You can't say, I need to add this, I need to add that. There's a very specific answer. Sometimes they're unmistakably clear. One thing I see all the time, and as far as ethical violations are concerned, not in schools, and you'll understand why in a minute, but for adults engaging in sexual relations with counselor and client. And you can understand those, therapeutic relationships. Sometimes they become, I mean, people become very, very close and they're very vulnerable. And people act on that more than you would think that they do. I'm not saying that that happens in schools. I'm just giving you that as an example. Our ethical codes are very, very clear. Don't do that. Don't sleep with your clients. But our ethical codes might say something else like, don't practice outside the boundaries of your competence. Well, what does that mean? Where am I competent? When can I refer a client or a student because my values don't align with theirs? Since 2014, I believe, I think it was 2014, we don't refer people because we don't agree with them anymore. We say our professional values say we're professionals, and even though I don't agree with you as my client, I can still work with you because I'm not imposing my own values on you, and there's no reason for me to refer you if I'm competent to work with you. So that can sometimes become a gray area. So that's what I mean. Ethical codes are necessary, but they're not sufficient for exercising ethical responsibility. Common sense. Be familiar with ASCA, and I also like the American Counseling Association. Um, these two organizations work very, very closely together for many, many years, I believe over 50 years. And I believe that they still do. They've always had their own separate ethical codes. If you read both of them, and I have my students do this as an assignment, where they look at the different codes and they have to compare and contrast. And obviously, the school code is going to be much more specific to how we deal with students, how we deal with parents, where the ACA code is going to be more generic, how we deal with all clients. There's some limitations. Some issues can't be handled solely by relying on ethical codes. I said earlier, that ideal model of conduct and consultation, I would say that that's the most important thing that you could ever do. You'll see this is going to be one of my benchmark questions later on down the road, but if you want to ever avoid losing a lawsuit, which counselors never lose lawsuits, so don't let me scare you. We always win because we do the right thing for the most part. Sometimes we screw up. But if you ever sat in front of a judge and the judge is going to ask you, what do your ethical codes say? Did you follow your ethical codes? And did you consult with someone? Would they have done the same thing if they were in a similar situation? If you can say yes, I followed my ethical codes, and yes, I did what someone else in my position would have done because I called them and asked them and we were in agreement, you'll never lose. So simply learning the ethics codes and case books will not necessarily make for ethical practice. You can read them, you can know the rules, but if you don't follow them, you'll have a problem. Ethical codes tend to be reactive. I think they give us pretty good guidelines about things, what not to do. I just gave you the example of don't sleep with your clients. That's not really a reactive piece. I mean, that's proactive. Don't do that. I think there's a lot of things that we know how to do, but generally when people dive into ethical codes, it's when something doesn't feel right. We're presented with a problem and we want to say, okay, has this happened before? Is there some guidelines? Is there an answer? That's what I mean by reactive in that case. I talked about this just a moment ago. Our personal values might conflict with a specific standard within an ethics code. Um, I don't think that that's the end of the world. I mean, we're always going to have personal values. You should never not have personal values. You wouldn't be genuine and authentic. I wouldn't want you as my counselor if you didn't have personal values. It's when you impose your personal values that become a problem. So even though your personal values might conflict with an ethics code, as long as you follow the ethics code, you're okay. If you impose your personal values and say, I don't care about the ethics code, that becomes a problem. I already talked about the next two bullets about the conflict between, institutional policies, school policies, state laws, regulations. And the last one is ethical codes need to be understood within a cultural framework. Everything we do comes from a cultural framework. In my knowledge, skill, awareness piece at the very beginning, when I gave you my learning objectives, I talked about explicit and implicit bias. That comes down to culture almost every time. So I just want to move on because we said we're going to talk about ethical codes, professional values, and then moral principles. Professional values are an important way of living out an ethical commitment. Here's the value, the noun. A moral, social, or aesthetic principle accepted by an individual or society as a guide to what is good, desirable, or important. This is the APA. Values guide our behaviors or exceed prescribed behaviors. They provide a conceptual basis for ethical principles. And one thing that ASCA doesn't necessarily point out in their preamble in their ethical codes like the ACA does, but they still provide clear values, and they just do it through their position statements, not in the preamble of their ethics codes. And if you haven't ever looked at position statements on the ASCA website, do it. And I'm just going to give you two examples just because I think where we are, this is timely. We're talking a lot right now about the Department of Education and diversity, equity, and inclusion, and some executive orders that have been signed. And um, regardless, this isn't. I'm not trying to make a political statement, but whatever your position is on, DEI in schools, ASCA has provided a cultural diversity position statement. They've also provided equity. So I'm just going to give you just the two of them, for example. I mean, there's dozens of position statements, which we as school counselors, these essentially are our values. And I gave you the website there at the bottom. So if you really just follow the schoolcounselor.org and follow the link to standards and position statements, they'll give you a lot of answers that you won't find in the ethical codes that you're wondering, like, well, what is we as a profession, what do we agree on and believe in as professional school counselors? So I'm just giving you just two examples here just to show you, but I want you to know that there are dozens of them. The first one on cultural diversity, school counselors have a professional and ethical responsibility to expand personal, multicultural, and social justice advocacy, awareness, knowledge, and skills to be an effective, culturally competent school counselor. Now, you can interpret that how you want, but basically what we're saying is we have an ethical responsibility to expand personal, multicultural, and social justice advocacy. What does that mean when there's someone telling us how we're going to work with diversity, equity, inclusion in the schools? And here our position statement says, as social justice advocates, how do we move forward with that? I think this one's equity. This is the second one. This will be the last one I show you just in the interest of time. School counselors acknowledge and value individual and group differences that exist among students. School counselors are advocates for the equitable treatment of all students and strive to establish inclusive and welcoming learning environments in which all students can thrive and reach their full potential. Again, I'm just giving you these two examples just in the interest of diversity, equity, inclusion, but these are our professional values. This is what we agree on as school counselors, these position statements. So the third piece of this was moral principles. Maybe you remember the moral principles. They've been around for a very long time. Counselors recognized them as early as I think 1984, 1985. With the first five moral principles, veracity came a little bit later, but we generally accept these six moral principles. Um, Autonomy really just means independence. This is the reason why, as counselors, we don't share our opinions with people. We don't give advice to people. What we've been taught is we work to allow people to come up with their own solutions. I mean, I approach counseling with the thinking that everyone already has all the answers that they need in life. Sometimes they just struggle finding those answers, and that's why there's counselors. We just help them find those answers that they already have. People are the experts in their own lives. So if we're promoting autonomy, that means just we're promoting independent thinking. We're allowing people to think for themselves and we're not thinking for them. I argue sometimes that I think this is the most important thing that we do in counseling. I have colleagues that I sometimes prevent with would say, well, how can autonomy be higher than non-maleficence, which is do no harm? Beneficence is the third one down, means just do good, do the right thing. So don't hurt people, do the right thing, allow them to think for themselves. Justice is to be fair, fidelity is be reliable. If you say you're going to do something, do it. Justice being treat everybody the same. If you have to treat someone differently, a student or a client, for example, then you should be able to justify why you're doing something different for that person that you did for other people. There's going to be times when we have to treat people differently. It's not common, but as long as we can justify it, we're okay. And then this last one here, veracity, is be truthful. So we don't necessarily mislead people. And I don't want to spend a whole lot of time on moral principles really reading them to you, but I've included them here in the slideshow. So go ahead and feel free to just pause at any point and you can read this. I kind of gave you the rundown in the last slide, but you can see a little bit more of a lengthy definition and some examples here. And I'm just going to move through the next two slides the same way. Just pause it if you want to read it. Again, we see beneficence and justice here. And then lastly, again, fidelity and veracity and how they pertain to school counselors. Again, I don't want to read these to you just in the interest of time. Just feel free to go ahead and pause and read it on your own. And then that brings us really to our first benchmark, which if we were in person, I would be asking you, what is the difference between ethical standards, professional values, and moral principles? Just based on what I said, could you tell me what the differences are? Well, I could tell you one thing that they all have in common is we as a profession agree on them. We set those ethical standards, we agree upon those professional values, and we follow those moral principles. We all do that. So I just want to quickly move through this next piece because the first part was ethics, morals, values, principles. This next piece here is going to be laws and policies. I talked earlier about district policies. A lot of districts don't even have formal policies specific to school counselors. And sometimes that, that could be a problem. But again, really the point that I'm trying to make is that district policies and laws, very, very different. Obviously, laws are going to supersede everything else. Policies are going to be, do you want to keep your job? You have things like statutory law, which is enacted by state or a federal legislative body, case law, which is one thing that we see. A lot of our ethical codes are really born out of case law because they're created by decisions by state and federal courts interpreting statutory law. They generally come from appeals courts, but almost every single ethical standard related to, your duty to warn comes from Tarasoff. Your duty to warn parents come from a case called Isel versus Montgomery County, Maryland. They were both decided by the court cases. Once the court decided, we looked at our ethical codes and said, hey, we don't have this. This is now 1971. But we didn't have in 1971 something that says, hey, we have a duty to warn a third party, someone that our client said, hey, I'm going to hurt this person in 1969, and when this case happened in 71, when it was decided, I'm talking about Tarasoff, there was nothing in our ethical code that said, hey, we got to go out and find this person and warn them that they might be in danger. Once the court decided that, hey, that's a thing, well, we updated our ethical codes to say, yeah, we have a duty to warn a third party. So a lot of our ethical codes will grow out of case law. Regulatory law is something that you're familiar with. It's created by an administrative body of government. The PDE, Pennsylvania Department of Education, is an administrative body. And then we have criminal law, which probably everyone's familiar with. If you've ever watched Law and Order SVU or any court TV, um, well, I would say any crime drama at nighttime, generally the civil law stuff is probably what you see during the day with Judge Judy. But the criminal law, it's a different type of you've heard the term beyond a reasonable doubt. You have to be 99% sure that something has happened. It places an emphasis on punishment. If we find someone guilty for murder, they go to jail. Civil law, it's a little bit lower. I'll give you an example. If you're old enough to remember O.J. Simpson, that they call it what was it? The trial of the century was O.J. Simpson. If the glove doesn't fit, you must acquit. If you're not old enough to remember that, do a quick Google. But O.J. Simpson was found not guilty in criminal law. Or in the criminal court. So he had a jury. The jury wasn't more than 99% sure that O.J. Simpson was guilty, so they found him not guilty. Now, that doesn't mean that he's innocent. That just means the court wasn't more than 99% sure, so they found him not guilty. We don't send those people to jail. Well, Nicole Brown Simpson, she went and sued O.J. in civil court, which is a different type of law. And in civil court, all you need is a preponderance of evidence. So you just have to be 50.1% sure. And if you can prove that, or you don't even have to prove, you just have to be, this was more likely than not to have been your fault, then we can find someone liable. You're liable in civil court, you're guilty in criminal court. Civil court, it really places an emphasis on dispute resolution. You hit somebody with your car on accident, you break their leg, they sue you for medical bills. That's civil law. The one thing about civil law is because we can harm someone, it doesn't have to be physically, it can be psychologically in counseling, but we can't give that back to someone. We can't untraumatize someone or unbreak someone's leg. So what the courts decided is the next best thing that we can do is give someone money, and enough money will make someone's leg feel much better. When I have the opportunity to present on mandated reporting law, I use this. And it's really just describes reasonable suspension. I talked about just a second ago, beyond a reasonable doubt, that 99% certain in criminal law. You can see the threshold is extremely high. The only thing higher than beyond a reasonable doubt is if we actually saw it happen ourselves. We could say, I'm 100% sure it happened because I saw it. But then we have that preponderance of evidence, which was more than 50%. That's the criteria for civil court. But under that, probable cause, you probably hear about did a police officer have probable cause to search someone's car? I think is probably the most common one. When we're talking about mandated reporting, it's believing a child was probably abused, could be probable cause, which is an extremely high standard. I mean, for reporting child abuse or suspected child abuse, it's actually very low threshold. You don't even have to believe that child abuse has happened to report it. Reasonable cause is suspecting a child was abused. Another mandated reporter should have the same suspicion under similar circumstances. Remember, that goes back to what I was talking about earlier on in the presentation, where I said that ideal conduct. That's what we're talking about, where someone in the same situation as us, another school counselor in the same situation where they have thought the same thing, that's reasonable cause. A hunch means no evidence or very little evidence exists. In order to make a mandated report, now remember this about mandated reporting. This isn't the purpose of my presentation, but I do want you to know this. You don't have to believe it. You don't have to see it. You just have to have just a little bit more than a gut feeling. You're not the investigator. And I think some people, when they call me for ethical consultations, they'll say, is this reportable? If you're asking me if something's reportable, report it. It's up to someone else to investigate it and decide if it has, if there's grounds. That's not up to you. You're just reporting it. Now, where the hunch piece, where it gets you in trouble, I'll just give you a quick story. There was a case in New York years ago, I believe early in the 90s, where a kid showed up to kindergarten with a black eye, and the teacher, without questioning the student, called the Child and Youth Services in this county in New York, and the Child and Youth Services showed up at the parents' house to investigate them. It was a small community. The parents were humiliated and embarrassed because of all the commotion and all the goings on, and the community knew that they were being accused of child abuse. And when CYS got to interview the child said, I fell off my bike yesterday. So now this teacher just humiliated these parents because it was just, child has a black eye, the parents must be abusing the child. So you got to have a little bit to suspect it. There has to be something more than there than just, hey, the kid has a black eye, report it. That'll keep you out of trouble. So benchmark number 2, what are the differences between laws, ethics, and policies? Again, laws created by civil entities, legislative bodies, things like that. They trump everything else. Ethics are created by us and our profession, what we know to be the ideal model of conduct and the ideal standard. Then policies come from school districts. So I talked about civil liability. I talked about tort law. I said I'd use them interchangeably. A tort's not illegal. You probably have heard the word tort before because you have car insurance. So you probably had to make a choice. Do you want full tort or limited tort when you were younger and you didn't have any money? Not saying that you have all that much money now as a school counselor, but you're probably doing better. You probably had limited tort when you were a teenage driver because your insurance is cheaper. What it also does is it tells you how much money you can sue someone for. As you get older, my law professors always taught me if you can afford to get full tort because there's no limit to what you can sue someone for. And that's just in Pennsylvania. Different states are different, but that's what a tort is. It allows the injured person to recover something because they were harmed. Because we can't give them back a brand new car or a unbroken leg, it usually results in us giving them money. There's two types of torts. Ones are intentional and ones are unintentional. Obviously, school counselors don't commit intentional torts. We don't intentionally hurt people. Sometimes we might make a mistake and unintentionally harm someone. Anybody could be sued for anything. You know that at this point. Very seldom do school counselors ever lose. Probably 99.9999% of the time will be successful in lawsuits, but on occasion, whether we gave someone bad advising about meeting NCAA requirements and they were offered a scholarship. And when they get to college, the NCAA takes their high school transcript and says, yeah, your counselor was wrong. You don't meet the NCAA requirements and we're revoking your scholarship. That's the only time I've ever seen a counselor lose. And really, it's not even the counselor that loses because counselors don't have any money. School districts do. And that's who they sue. So again, here's negligence. It's just the unintentional violation of an obligation that we owe to one another. Most of our torts are unintentional. And as I said earlier, negligence, it's a failure to exercise the level of care that a reasonably prudent person would in like circumstances. Reasonably prudent person, we can call that reasonably professional person. Just what would another school counselor do if they were challenged with the same situation as you? Would you do something different? You always want to say, no, the majority of school counselors would do it this way, and this is the way that I did it. Negligence claims are analyzed in four stages. You have to show that there was a duty owed, that it was breached, that there was an injury suffered, and that the counselor was the proximate cause of this. The reason that counselors never lose lawsuits is because they're never the proximate cause. Even though a student was hurt, for example, very seldom is it because of what the counselor did that the student was hurt. The example I just gave you a minute ago, where the counselor gave bad advising, said, yeah, you meet the NCAA requirements, your scholarship, you're fine, and the student said, okay, thank you for that advice, that was the proximate cause. That was the counselor's fault. But in other situations where, counselors have made bad referrals and students were, went to inpatient and were abused in inpatient, there are students who've completed suicide where the counselor had interviewed the student about their suicidal ideations and the student still completed suicide. At the end of the day, there's always been an injury, but it's very, very difficult to show that that injury was caused because of the decision that the school counselor made. If you want to know more about this, come see another one of my presentations when I do just negligence, where I can do a deep dive on all four of those cases that I've been talking about today. The reason that negligence is hard to prove because if we fail in any one of those elements, the case is thrown out. This is probably one of the reasons why school counselors never lose. So we know this duty owed. Basically, if we're in a special relationship with someone, and special relationship is defined by the law, it's basically if you're a school counselor and that's your student in your office, there's a special relationship there. That's a little bit different than, you and a colleague or you and your buddies or you and a friend. So the duty of the professional school counselor is to protect students or identify others against reasonable risk. That came out of the Tarasov case in 71. The duty intensifies as the risk increases. So when we're talking about students with suicidal ideations, that's about as of an increased risk as we're ever going to get when we're talking about death. So our duty becomes greater. And because we work with children, we're always elevated in our level of duty because we work with kids. The law doesn't trust that kids can protect themselves. So the law protects kids and the law entrusts us as school counselors to protect kids. So the question that you ask yourself is, what would a reasonable person of ordinary prudence exercise for the safety of others in like circumstances? Again, I keep asking this question over and over and over again because I'm trying to demonstrate this ideal model of conduct. It's the one question that you're going to have to answer if you ever find yourself in court that I didn't do anything different than any other school counselor would have done in the same situation. In fact, I consulted with the ideal model of conduct, the one person that I know that would always do the right thing. This is what they said they'd do, and this is what I said that I would do. Because we have master's degrees, we're trained in mental health law. Sometimes we're held to a higher standard than what a normal person without any training in mental health might have been. I talked about that duty to warn just a little bit earlier. It just means that sometimes we have to breach a student's confidentiality if that student presents a danger to someone else. We have a duty to protect. That goes again back to that Tarasov case. Maybe I'll take a little bit of a different spin on it because I don't want to keep talking about Tatiana Tarasov. You probably remember back in, I want to say 2014, if you're a Penn State fan, kind of big scandal at Penn State University because someone said, well, there was Jerry Sandusky was, sexually molesting children in the locker room. And our laws back in 2014 said, okay, there's an administrator of that institution, and that administrator is the only person that will report to the state, to Childline. Obviously, now you're familiar that everyone Childlines. We do it online now, but everyone does that if you have this suspicion. Where Penn State got in trouble is their fail to act. So they knew that it was happening, they just didn't tell anybody. So just because they ignored it like it wasn't happening, they weren't protecting people by not doing anything, and that's what got them in trouble. So my last benchmark, what are some of the steps professional school counselors can take to be protected from lawsuits? I think understand those four elements of negligence, understand what the proximate cause is. I would say if you've ever met someone who's a good storyteller who can talk about those different cases and say, here's what they did in that case. And not because I'm saying this is the reason why we contact parents when we talk to a student about suicide. It just gives you a different way to think beyond your ethical codes. And the one thing I'll say about civil liability is it's not taught in schools. A lot of professors don't understand it. I understand it. I went through law school to understand it. I was just able to relate it to school counseling, but sometimes we avoid things that we're not completely comfortable with or 100% positive about. If you haven't had any training in lawsuits, proximate cause, the elements of negligence, civil liability, tort law, certainly seek out some professional development opportunities in that case. Now, I believe this is going to be my last slide, and I wanted to leave you with an ethical decision-making model because, I mean, I think this is a great opportunity. What I use the here, Leahy and Corey. You'll see my citations here over on the left side of the screen. And you'll also see the American School Counselor Association has their own. What I did is I combined them. And number one is just to identify the problem. You feel something isn't right because you've had that training. Well, what's the first thing you're going to do? You have ASCA ethical standards, open them up and read them, but also look at the professional literature. And what I mean by professional literature is if you're a member of ASCA, you subscribe to a journal. They send you a journal. I can't remember if it's quarterly at this point, but read it. Or go online and look at it. Google Scholar, just Google things, really. You can also find a lot of literature just based on those position statements I showed you earlier. And then you should probably know your district policies because these are going to guide you on how you want to approach the ethical decision. Those moral principles, the 6 moral principles I talked about earlier, how do they fit into the problem that you're having? Now, one thing that ASCA recommended was consider the student's chronological age and developmental level, which you won't see that in the ACA models. ASCA also says consider the parental and guardian and the student's rights because when we're working with minors, parents have certain rights that over their children. Again, I can't say this enough. Consult with your colleagues, supervisors, or experts. You're always free to send me an email. I'll give you a consultation anytime you want to the best of my ability. And if I can't, generally my consultations are good when it comes to legal issues. But if I can find you an ethical, another one of my colleagues or someone who specializes in different ethical codes, be happy to send them in the right direction. And number 7, I love this, is attend to your emotions because a lot of the times are we mad? Why are we upset? Is something really bothering us? Because we're advocates for people and we're humanistic practitioners. We care about people. When we see people getting hurt, that doesn't sit well with us, especially perhaps when we're the one who hurt the person. Attend to your emotions, and sometimes we have to seek our own supervision at this point. I've always involved my students in the ethical decision-making process. If I ever had to make, let's just say I had a conversation with a student that was difficult, and I knew that I was going to have to breach confidentiality, and I was going to need to contact their parents. I would have the conversation with the student first. I would make sure they understood why I was contacting their parents, and I would let them dial the number on the phone, say, hey, mom, it's me. I'm with the school counselor. He wants to talk to you. We're going to put you on speakerphone. Is that okay? And I would have a conversation with the parents and I would allow the student to sit there and hear everything that I said. And that was more or less me keeping trust in the therapeutic relationship, but involving that student in the process. There's no secrets in counseling. There's no reason to ask a student to leave the room while I talk to your parents. We talked about multiculturalism early on. So consider the cultural context of the client or the student and even their family. If we're talking about a collectivist culture, an individualistic culture, how a student is going to approach mental health is going to vary just based on their family values and family traditions. And so it doesn't necessarily have to be race or ethnicity. And then as we get a little bit further, identify some desired outcomes. What are some potential courses of action? Are there any consequences to those courses of action? Evaluate the selected course and then implement it. Select something and then implement it. At the conclusion of all of that, after you're done implementing, you really kind of want to reflect on it, identify any consistencies in the school district policy, and if something needs to be revised or updated, then that's on you. That's something for you to do. So that's going to be the end of it. I appreciate you being here and listening to me, and I will look forward to your questions.